In Hamilton Health Sciences versus DH, the Ontario Court of Justice had to decide between saving a child's life and respecting a parent's rights. This case involved an 11-year-old girl with leukemia. Doctors stated if she underwent chemotherapy, she would have a 90 to 95% chance of survival, but no child had survived this cancer without it. However, her mother decided to stop chemotherapy and instead opted to take her child to Florida for alternative treatment. Under the Healthcare Consent Act, a person can only make their own treatment decisions if they're capable, meaning they understand the treatment and can appreciate the consequences of accepting or refusing it. Note that there's no fixed age of consent underneath the Healthcare Consent Act, and the court found that the 11-year-old was not capable since she could not understand the consequences of refusing chemotherapy. Because of this, the law requires a substitute decision maker, her mother. The doctors were concerned about the mother's refusal of treatment and asked the court to step in under the Child and Family Services Act. Under this law, a child can be declared in need of protection, and this would allow for the treatment to continue and for the child to get chemotherapy. But the court refused, stating the child was not in need of protection due to two key details. The mother was a caring and loving parent, and she was acting based on her indigenous beliefs. Under Section 35(1) of the Constitution Act 1982, Aboriginal and treaty rights are recognized and affirmed. The court held that her decision to pursue traditional medicine was legally protected under this clause. However, this raised serious legal concerns, since substitute decision makers are only allowed to make decisions for someone that is incapable based on the patient's best interests and not their own beliefs. However, the court allowed the mother's cultural and constitutional rights to influence the decision, even though the alternative treatment chosen had no proven medical benefit. Later, when the cancer returned, the mother decided to restart chemotherapy alongside traditional indigenous medicine. The court clarified that best interests remain the most important factor, but indigenous rights must also be considered. The court clarified that best interests remain the most important factor, but indigenous rights must also be considered. Because both approaches were combined, the child was not considered in need of protection. So, what does this case mean for individuals? Normally, if a patient is found incapable, their substitute decision maker makes decisions following the patient's best interests underneath the Healthcare Consent Act. However, this case showed that medical facts are not absolute in law. The court allowed cultural and constitutional rights to influence a life or death decision. This reflects an important principle in healthcare that must be respected: autonomy. The idea that individuals or their families, when necessary, should have control over medical decisions, even if those decisions are risky or controversial. It ensures that when you or your family face serious medical choices, your beliefs, culture, and values are taken seriously and not ignored in favor of medicine alone. For the healthcare system, this creates a few challenges. Doctors are trained to act in a patient's best medical interests using scientific evidence and proven treatments. However, this case shows that law does not always align with medicine. It also shows the hierarchy of laws in Canada. Rights underneath the Constitution Act can outweigh other legislation, such as the Healthcare Consent Act. As a result, healthcare professionals must not only consider medical evidence, but also legal rights and cultural practices, which can create serious ethical dilemmas in some cases, like this one. It also places pressure on hospitals and child protection agencies to balance patient safety with respect for rights, sometimes requiring court involvement. Overall, decision making becomes a lot more complex and uncertain when legal rights and medical evidence conflict. Overall, this case shows that healthcare decisions are not just about saving a life, but about balancing law, rights, and medical judgment, even when the outcome differs from what the doctors would choose.